What happens when new evidence explains why a constitutional claim was never properly raised? You might think a higher court would examine it. You would be wrong. In federal habeas cases, a court may refuse to consider evidence because it was not first presented in state court. The state court did not see it, so the federal court says it cannot use it. But what if the very reason it was never presented was another attorney's failure? Then the evidence can become trapped between courts. One court did not see it, the next court will not see it, and the person in prison continues paying the price. That is happening in Jason Green's case. His trial attorney made a mistake at trial. He then tried to correct the mistake and later signed an affidavit stating that the failure to object was an error, not a strategic decision. But the affidavit was not part of the state court record due to a failure of post-conviction counsel, so the federal courts have refused to treat it as evidence when reviewing the state court decision. Think about that. The document may help explain the attorney's failure, but the attorney's earlier failure is part of why the document arrived too late to be considered. They call that procedure. The person behind bars experiences it as years of life. Courts need rules, but should evidence be locked out of every courtroom because the first courtroom never received it? Read the documents at thishappenedinalabama.com. No money requested. Watch, repost, comment, share. Tag someone who believes evidence should be examined before a courthouse door is closed.